Hi real estate professionals, and welcome to Velocity Title's Title Minute. Today our very knowledgeable real estate attorney Glenn Donaldson will be discussing breach of the buyer-broker agreement, how to avoid a mistake that could cost you your entire commission. At the end we'll share our contact information where you can send in any questions or comments you might have, and we'll get back to you as soon as we can. And now here's Glenn.
Well, thank you again, Lauren, and welcome back everybody to the Title Minute by Velocity National Title Company. I'm your host, Glenn Russell Donaldson, your real estate attorney. And today I want to talk to you about the two main contracts that are related to listing a home for sale and with the buyers, and that of course is for the sellers, and with the buyers, the buyer agency agreement when you're engaging a contractual relationship with buyers who are out there looking to purchase real property. One of the main things that the consumers and the real estate professionals want to be sure of in these agreements is that all of the material terms are actually included in the listing agreement, which is with the seller, and the buyer's agency agreement, which is an agreement between a brokerage and a buyer in order to sell that buyer to show that buyer a particular home and sell that buyer a particular home by representing them and drafting the contract of sale and any of the other ministerial matters that need to be taken care of during the process. So what I'm talking about is one of the main issues that has come up in recent years is the issue of the buyer agency agreement having a blank term in paragraph 7 relating to the commission compensation. Now this is important for both the real estate professional, of course, and it's important for the end consumer. So the buyer agency agreement essentially sets forth that the real estate licensee is going to create a fiduciary relationship with that buyer, meaning they have a legal relationship where they represent the interest of that buyer in the transaction, and there is an agreement for compensation. Now typically and historically what happens is a seller lists their property, and in the listing agreement they've agreed to a certain commission compensation that they will pay the listing broker. The listing broker, for example, will agree to a 5% listing compensation. When they put that 5% listing compensation in the multiple list, the parties have agreed, and the seller has agreed with their broker, that the broker will cooperate with other real estate brokerages who bring buyers to the property and present contracts that may get accepted by the seller. And then you may see a split. Typically 50% goes to the listing broker, 50% goes to the selling broker. Those terms are negotiable. However, sometimes there are situations where the selling broker presents a contract to a seller, and the sellers are not going to pay a commission compensation to that buyer's broker. In those instances, the buyer broker is only going to be able to be compensated directly from their buyer under the buyer agency agreement. If that buyer has a contract with that buyer's buyer broker under a buyer agency agreement where the commission compensation in paragraph 7 is blank, well, what's going to happen is it's going to be an unenforceable term. Remember, in contract law, the court is only going to look to what does the contract say, the four corners of that document. It's called the four corners of the document rule. And when they look at paragraph 7, it's going to be the compensation to be paid to the real estate brokerage is 0. If you have 0 or something that might say seller to pay per MLS, what you're effectively doing is you're entering into an agreement with a buyer that says they owe nothing. Nothing. No matter what happens with the seller, the buyer owes nothing. There's a case just recently on this that I represented a brokerage, and we had to tell the brokerage, I'm sorry, you're not going to win this. you've entered 0 into the commission compensation, and you've agreed to collect 0. That is what your contract says. Make sure, if you are the consumer, make sure if you're the real estate professional, you've looked at these terms and you've got them properly executed and filled in. They are material to your agreement. Once again, if you have questions, reach out to us at contractquestions@velocitytitle.com, or please check out our contract hotline. That number is 1-800-MY-RE-LAW. That's 1-800-MY-RE-LAW. Or if you prefer the numeric, it's 1-800-697-3529. Once again, I'm Glenn Russell Donaldson, your real estate attorney.